Are you planning to apply for an EB2 visa and wondering how the new changes to the NIW guidance would impact your journey? Well, stick around. This update could change everything you know about the process. So I'm here to help you out. Hi, I'm Simon Shetty, your host and the founder of Smart Green Card. And in today's video, we'll break down the latest USCIS guidance on EB2 National Interest Waiver petitions. Now, why is this really important? That's because these updates could make or break your immigration application. Now, whether you're a STEM professional, an entrepreneur, or even someone with exceptional skills in your field, this video will guide you through the key changes and what they really mean for you. So let's dive in. Before we dive in, a quick heads up, I'm not an immigration attorney. No one in my team really is. So this video is just for educational and informational purposes. If you need specific legal advice, you should always consult a US licensed immigration attorney. None of what we say as part of Smart Green Card should be construed as legal advice. First, let's start with the basics. The EB2 classification is for professionals holding advanced degrees or individuals with exceptional abilities in the sciences, arts, or business. However, if you have a bachelor's degree and at least 5 years of progressive work experience in the field, you may still qualify based on the strength in your overall profile. So usually an employer has to sponsor you, get a labor certification from the Department of Labor, and that's a long process in itself. EB2 NIW, or this entire process right now, is a game changer. If your work is in the national interest of the United States, you can file for something called the National Interest Waiver and skip that employer sponsorship requirement altogether. This also means more flexibility for you as a petitioner, and you can even file on your own behalf. And here's what's changed. USCIS updated its policy manual on January 15th of this year with some changes on how they review these petitions. So these updates are effective immediately, and here's what you need to know. First of all, for advanced professional classification, they are paying closer attention to whether your job qualifies as a profession and whether you have met at least 5 years of experience in that relevant field after earning your bachelor's degree. The second thing is that if you are claiming exceptional ability, it should directly relate to the work that you are proposing. USCIS will evaluate your specific expertise, knowledge, and skills on a case-by-case basis and then determine how they relate to your broader work. Now, when it comes to supporting documents like letters of recommendation and business plans, etc., there has been a slight shift. These documents will no longer automatically support prong 2. However, they are still valuable in other parts of the process as long as they are detailed and well supported. Number 4, the urgency factor, such as public health, which was going on during COVID, or safety for that matter, has been removed from prong 3 and merged with the time-sensitive contributions. So STEM is still important, but the focus has shifted to how your qualifications align with more impactful proposed work in that endeavor. Number 5, the new policy update clarifies that in entrepreneur cases, the general assertions about job creation or economic impact aren't really sufficient. Demonstrated history, a clear national significance, and a robust evidence pool are more vital right now compared to ever before. And number 6, finally, USCIS explains that when evaluating national importance, they focus on the broader impact of the proposed work within a field or region rather than the specific job title or occupation. Now, to sum it up, the recent updates to the EB2 NIW might seem a little bit daunting, especially with the buzz circulating online, but the changes are fairly minor. Most of the core guidance remains unchanged, and with a few additional examples to clarify existing practices, not a lot of it has changed, but these clarifications do help you evolve your profile in a way that it is nationally significant. Now, while there are some adjustments in how letters of recommendations are treated, it is also crucial for you to stay informed and observe how these updates unfold when they apply it when cases are getting adjudicated. Ultimately, staying knowledgeable is the key, especially in very subjective cases like the NIW, the EB1A, the O1A, etc. Whether you are navigating the process on your own or with a legal professional, keeping up to date with all the rules will make sure that you are well informed in your decisions as well. If this information was helpful, don't forget to like this video and subscribe for more updates. If you have more questions, drop them in the comments below. Remember, staying informed is the first step to achieving your immigration goals, no matter what the challenge might be. That has helped me throughout the past several years in my immigration journey as well, and several of our clients that have gone through the same journey, and I would wish the same for you as well. This is Simon Shetty signing off. Until next time, stay smart, stay informed, and forever stay focused on your journey.